Hello, welcome to LGBTQ Family Formation Law and Reproductive Rights, sponsored by Quimbee. I'm Colleen Quinn, and I'm a practicing attorney in Richmond, Virginia at the law firm of Locke & Quinn, and I've been in practice for 32 years now after clerking for the Chief Justice of the Virginia Supreme Court, and before that graduating from UVA, that's University of Virginia Law School. I'm a member of the LGBT bar, especially the Family Law Institute of that organization, and also of the Virginia Equality Bar Association, and have worked with Equality Virginia on multiple pieces of legislation in Virginia that favor LGBT family formation. I've also written several articles, including for the University of Richmond Law Review, entitled Riding the Storm Out After the Stonewall Riots, Subsequent Waves of LGBT Rights in Family Formation and Reproduction. And it's in part that article that I wrote, the Law Review article, that forms the basis of this program. So let's dive in and talk about the waves of LGBT family formation starting before the Stonewall Court riots. So I would say wave one, which is the pre-1970s, pre-Stonewall Court riots, was an era where LGBTQ individuals primarily had children through heterosexual marriage or other means, and families often lived in secret or hid their relationships. And then we moved into wave two, the 1970s to 1980s, where many LGBTQ families adopted children out of foster care. Gay marriage and adoption became somewhat intertwined, with adoption being used as a way to legitimize relationships in lieu of being able to get married. Joint adoptions were rare. Most adoptions were by a single LGBT parent. There was some second parent adoption, but it was limited. And the legal landscape was kind of uncharted and messy. The state laws varied widely from state to state. The key events during that Wave 2 period were in 1977, the formation of the National Center for Lesbian Rights. In 1978, there was the Washington State Supreme Court decision issuing the county's first custody rule in favor of a lesbian couple. That was the Schuster versus Schuster case. And in 1979, a gay couple in California became the first to jointly adopt a child together. And then we moved into Wave 3, which was really the 1980s into the 1990s. And that's when assisted reproductive technology, which I commonly refer to as art, that's not art that you hang on your wall, but we refer to it as art, that became more popular. Self-insemination with everyday objects such as eyedroppers or turkey basters became more prevalent. The book Our Body, Ourselves came out. Gay men were often the source of sperm for lesbian women. Sperm banks did start to develop, and the fertility options and clinics became more advanced at that time for straight couples, although not really accessible to gay families. So the key events during Wave 3, when we look at them, in 1982, the Sperm Bank of California opened. In 1985, second parent adoption case in Alaska was a highlight. 1986, the National Council for Lesbian Rights won a high-profile second parent adoption case. Then in that same year, 1986, the Bowers versus Hardwick decision came out, which hurt the LGBT community because the Supreme Court of the United States said that the sodomy laws could be enforced by the states. However, 2 years later, in 1988, there was Artie Wallace case, and again, the National Center for Lesbian Rights won a custody fight by an AIDS-infected parent in California. And that same year, 1988, Collage, the Children of Lesbians and Gays Everywhere, was formed as an independent national organization. So there was a lot of movement that started to happen as we headed into what I call Wave 4. Wave 4 is really from about 1990 until 2016. And during this time period, this was a much, much larger wave with a lot more action to it. LGBTQ families being formed started to garner more publicity. That started to create some backlash. We had child welfare organizations that began to study the fitness of LGBTQ families. Gay marriage was banned by the Defense Against Marriage Act that we refer to as DOMA. And then it was overturned later in 2013, and then gay marriage was legally recognized, at least under DOMA, the Defense Against Marriage Act at the time. And then we moved into 2015, where after Obergefell in 2015, it became easier for LGBTQ couples to adopt jointly. It actually happened sooner in Virginia, where I am. We had marriage equality as of October 2014, when the Eastern District case that went up to the Supreme Court had writ denied, and so we actually had it a little bit earlier than the Obergefell case. And I remember in the Academy of Adoption and Assisted Reproduction Attorneys that I belonged to at the time, when it was just the American Academy of Adoption Attorneys, there were debates. We had debates about gay adoption and whether children in same-sex adoptive homes were faring worse or faring better. And they were somewhat uncomfortable debates between folks in the organization that were more on the religious right and less accepting.